That let's have our break tea now. It's 9:15, so we can pick tea. I think that's the position, right? We pick the tea and then come in, and then we start off. Said that we try to catch up with time and finish a bit early today. So I seek your indulgence for 10 or 15 minutes, as the team said. For our online audience, you could grab yourself a cup of coffee as well. I will be starting shortly. We're taking a tea break first, and then we'll start officially. Thank
Aramutse ihangane bari gushyiraho icyayi hagati aho mwaba musinya attendance ari inyuma noneho mugaceka ko amazina yanyu yanditse neza kuko amazina yanditseho niyo ari buze kuri certificate. Reka tuyacekinge dusinye ubundi iminota mike icyayi kiraba kigezeho. Mose
Okay, good people, we're starting with tea. It's time for tea. Then we turn the whole.
Good morning, ladies and gentlemen. Welcome again to today's session. Today, I know it is Friday, so we'll try to finish a little bit early so that you also have time to go and do your weekend stuff. So far, your opinion on the training, is it something that is, do you get the content that you is going to help you? Yeah, genuine opinion about so far what we've done. Yeah, I want an opinion from you. The training, the content that you're getting.
Thank you. I think it is very useful, especially what we saw yesterday. Some of us probably had, had a glimpse of it somewhere else in our daily work, but we got again to be reminded and refresh our mind, and we are looking forward to the session today.
All right. Any other person again? Opinion? Before we start, do you have anything to say, my friend?
Thank you. Thank you so much. So as a practitioners lawyers, I've got like a new skills which is very helpful and useful in our daily practices as lawyers. So a part of the law, maybe we can read the laws and other legal instrument, but those content you have seen yesterday was very useful when we plead in the courts. So we have to go deep as it's like a new sector, even in our courts. So I can thank you. the content of yesterday. Thank you.
All right. Yeah.
Okay, thank you. Actually, I've got this training so fruitful and very essential in a modern world, in the sense that we are living in a digital world, and I don't think that we as lawyers we should be lagging behind. We need to cope up with the new world, and the better way to cope up with, in terms of law and evolution, we need to go with the technology. And you can't go with technology when you don't dig deep in what technology requires and how you can use it, maybe defend your client to plead before the court. Otherwise, if we can't move with digital, then the world of the law will remain behind. We can't cope up.
Thank you. Last one. Gender sensitive, a lady.
Thank you. I will not go far or different from what my colleagues have said. I think the course is very helpful. Some of the things were just a bit technical, and obviously we can't become experts in forensic data and evidence gathering. That's for the forensics guys. But it's always beneficial to get an idea of what you're dealing with, especially given the age and era we're in. So it's always helpful as lawyers to know what are we dealing with? How does this development, how does this digitization impact the legal career or the legal sphere? So I think it's really helpful and looking forward to today as well. Thank you.
Good. Thank you. What is important as a lawyer, if you are in defense, always look at the evidence, digital evidence. It is very easy to dispute. If you can just create some doubt on the credibility, authenticity, and integrity of that evidence, then the judge, you can actually win your case. The only thing is that you try to see how you can poke holes on that digital evidence. That's it. Because most of the time you find even the judges, they are not aware of this. And if you are not aware and the judge is not aware, you can lose. So it is important just if digital evidence has been presented before the court and you are on the defense, please just try to see how you can be able to discredit that evidence in terms of validity, in terms of authenticity, in terms of integrity. So we are going to look at 3 items today. The first one is identification of digital evidence. Now, identification of digital evidence, this is what we are going to look at. Describe the basic steps to secure the scene, illustrate steps for conducting a short interview, explain how to handle digital evidence. When you get the digital evidence, how do you handle it? This is very important because this is where somebody is going to challenge you in court, how you handle that evidence, the process of handling that evidence. Outline the steps to document the scene and decide on the collection strategy. Yeah. So when we talk about the identification of digital evidence, identification is the process of identifying potential sources of digital evidence at a crime scene. Now, when at the crime scene, ensure safety of all personnel and steps should be taken to ensure that they are not placed in danger. Now, here is a case where you go to a crime scene and you have how many computers? You have, let's say, 20 computers. You have 3 mobile phones. You have 3 tablets. Now, how do you identify which of these devices has the digital evidence you are looking for. So you get to do a triage and only collect the devices that are actually have got the evidence you are looking for. Because you cannot collect 20 PCs to go and analyze them in the lab. You need to identify which particular ones have got the evidence that you are looking for. So you need to secure the scene, just as the normal crime scene. You need to secure that scene. Introduce yourself, the occupier of the premises, and the purpose of your investigation, if you happen to go there. And sometimes this thing is very tough because here is a case that way you are equipped with a search warrant. But you see, nobody, you go to their premises, nobody is going to easily surrender their PCs to you for investigation, especially if they know that this device has got incriminating evidence. So it will not be easy. Sometimes you go there and somebody just knows that this mobile phone is the one which is going to put me in for 30 years. By the time he reaches, he just takes the mobile phone and bangs it on the wall. And then how do you get your evidence? So you expect to meet such kind of things at the crime scene. Identify person in charge of the premise and everyone else in the premise. Then establish the surrounding and key evidential area like the server room. Look at, check all the rooms in the premise and identify digital evidence, because they will always hide this thing from your view. They will always hide the devices that are possibly carrying the digital evidence from your view. So you need to check everywhere to see if you can get that piece of device. Check the occupiers' vehicles and all other possible location, and move people away from digital evidence because they might interfere with it. Conduct a short interview. If you go, this is the suspect. You call the suspect and you sit down with the suspect and you conduct a short interview. And why do you conduct this short interview? There's some information that you need to gather from this person. One of the information, the first piece of information that you need is the purpose of the digital evidence. This particular device, what is it used for? So that you know what is the motive of use. If this evidence was used to save, let's say some information of criminal nature, what is the motive? So having a short interview will help you gather information like the purpose of the evidence, the users of the digital evidence to establish the owner of the evidence, because that evidence actually belongs to somebody. So and that is the evidence, that is the digital evidence that you are looking for. Any offsite storage to establish the other sources of evidence. You can go to a place and as I said, you ask these people and they tell you that we do not keep the data in these premises. The data is not on-prem. The data is actually offsite on the cloud, in a cloud storage. So what you need to do is that you need to expand your legal authority. Your search warrant must be able to cover even the cloud, so that whatever you're going to collect from the cloud is going to be admissible because you've collected it legally. Okay. You also need to take things like the username and passwords for each device. Let me tell you, especially nowadays, mobile phones are very secure. So if you pick a mobile phone, make sure that with it, you tell that person to give you the password, because most of the forensic tools right now, they cannot bypass the password on a mobile phone. So you need to see how you can pick that password, because otherwise it's going to, you are not going to do any investigation, because if it is locked, how are you going to open it? So ensure that the password, you take it from the suspect. If it is for the password of the cloud, password for the computer, these things you need to pick them as an investigator. handling the digital evidence. Now, first of all, document. And I stressed this yesterday that for this evidence, for you to convince the court that this evidence has not been tampered with, it is important that you do a lot of documentation. And you remember what you said, documentation starts by the time you collect that evidence from the crime scene until that the evidence is now disposed or taken back to the owner, which means that after the court hearing, that's when you take that's when your documentation stops. Otherwise, you need to maintain that chain of custody from the time you pick the evidence from the crime scene until the time that case is over. That is what we call the chain of custody, and we looked at it yesterday. So document the original location and condition of the digital evidence. Photo and video recording may be used in addition to written notes. You are starting your chain of custody from that point. Second thing that you need to do is to label the evidence. Now, labeling evidence must be unique. Each and every evidence that you collect, it must have a unique labeling, because that label stays with the evidence until the case is over. So, for example, you can go to a place and you get a mobile phone. And that mobile phone itself has got digital evidence. And a mobile phone might have an SD card with it. And it also has also a SIM card with it. So you have 3 pieces of devices here where you can extract digital evidence. So you must make sure that you tie the mobile phone to the SIM card and to the SD card. So how do you label? You can see how you can pick the label. For example, if I put the mobile phone, I give it HP01, but that is for the smartphone itself. And in the smartphone, we have the SD card, which was inserted. So you must make sure that you tie the SD card with the mobile device. So you can see that an example of HP01-SD01. So I know that when I take this to the lab, this SD01 belongs to this particular mobile phone. You keep that because these devices, this labeling will stay with the device until the case is over. Then sealing, you need to seal the evidence using a proper container. The seal must be signed and dated by officer holding the evidence. Each time evidence is accessed, the officer must also reseal. Sealing, you have, there are certain, let me just show you. You'll have something like this, step like this. So once you click that evidence, it has to be sealed properly before it is taken to the lab. Okay? So you seal the evidence, but if somebody needs to access that evidence and removes the seal, they do what they want to do and then reseal it again and make sure that they sign it. Okay? So that is the evidence. You just pass it around for people to see it. Then you seize that evidence. Seizing means just now you're picking it and people will, you're taking it to the lab. The evidence must be protected each and every time you pick it until the case is over. Remember, this is a case, if it's a high profile case and you picked a mobile phone, if you don't protect this mobile phone, it can disappear before you reach the lab. So need to really protect this thing. This is the only piece of evidence that you can make or break your case. So you need to protect it properly. When it comes to storage, the evidence must be properly stored. And anybody who is going to take that evidence from the store must sign off that you are picking this evidence. And when you are returning it back, you need to sign it again. So there must be check in and check out at the digital laboratory where the evidence is stored. Documentation of the scene. That one I've talked about over and over. Make sure that you can use the photograph, or you can use video to record the evidence, making sure that this is, if there's any defect on that evidence, that you might need to also photograph it as well. Just like when you go, a police case, you go to a murder scene. These guys will make sure that before they pick the body, they photo everything, including the environment where they found that body, how the body was lying. The same thing when happens in the digital world. You need to photo that particular device to see how that, before you touch that device, how was that device? Is there anything that was any defect within that device? Then after doing that, you decide on the collection strategy. Remember what we said. When you are going to collect that evidence, you do not need to work on the original. So how do I collect that? I need to do bit by bit copy of the original, or if you found that evidence that computer or mobile phone is on, then you need to collect anything that is in the RAM first, because there can be a lot of information in the RAM. Okay? Powered on system, yes. Examine the computer for any running processes. If it is observed running a destructive process, then the examiner should stop the process and document the action taken. Also determine if any running processes are related to the cloud or offsite storage. When encountered, the examiner should coordinate with the appropriate legal authority to ensure scope covers the offsite acquisition, so that evidence becomes admissible. Remember, if you collect any evidence that is not in your legal authority, or which is not in the search warrant, that is not going to be admissible in the court of law. Evaluate the impact of pulling the plug and shutting down the computer. This typically depends on the operating system. We talked about pulling the plug and shutting down the computer. Remember, shutting down the computer or pulling the plug, remember, anything that was in the RAM is completely lost. And that could be where the evidence you are looking for is residing. Packaging. Ensure that all digital evidence are collected is properly packaged, labeled, photographed, video recorded, and sketched, and pack all evidence in anti-static packaging, because plastic bags and containers can produce static electricity and allow the development of humidity and condensation that can damage digital evidence. The other thing is package digital evidence in a manner that it will prevent it from being bent, scratched, or otherwise deformed. Label the containers properly. This is when you are packaging them. Leave phones in the power state in which they were found. Package phones in radio frequency shielding material to prevent them from accessing communication links. Now, when you take a mobile phone, and nowadays you see most of the mobile phones have access to the cloud. Okay, especially let's say you have iPhone, there is the cloud aspect of iPhone. Now, if you're not careful and you pick this mobile phone, you put it in an anti-static bag, the suspect, knowing very well that this phone has got evidence in it, they can synchronize that phone to the cloud and delete all the data. By the time you reach your laboratory, all the data is gone. So what do? You need to use what we call frequency shielding material, or you put that phone on flight mode so that it does not communicate to the outside the world. Let me just show you one here. to test something here. You have a phone? You have a number? Call and put it on a speaker here. You want here? Yeah. Put on put speaker. Yes, also. Yeah. It's string. You didn't put it in sound. Yeah, put it in sound. You want here. You want here it's running. Yeah, put it. You want here if it's ringing. Yeah, call again. These phones are in close proximity, right? Call again, please. Call again. It will.
We just made one sound and disappeared. Huh?
Okay. Yeah, that's good. But we've seen that the phones are ringing, right? Yeah. But it's ringing, it's for calling. I want you to put your phone here. I want you to call this phone now.
The telephone number you've dialed is not available. Please try again later.
The telephone is here and it's on. Okay. So the purpose of this is the suspect. You get the suspect, and as I say, the suspect who is very clever enough will make sure that they synchronize their phone with the internet and delete all the data. So when you put this phone here, it does not communicate to the external world. It is completely, it is on, but not be. No, this is the, what we call Faraday bag. Yeah, you can, yeah, just pass it around. That's what we call Faraday bag. What it does, it prevents the phone from communicating to the external world, so that the suspect will not be able to delete the data when the phone is on that particular bag. If you don't have this bag, then you make sure that you put the phone on flight mode, all right? Yeah, the phone will not be available when it is in that bag. Your phone was here and it was being called and it was saying that is not available. Yeah? No, you can't receive the missed call. That's it. Yeah. That you can't see, it is completely out. You can't communicate with it. The reason is you are preventing the suspect from deleting the evidence from the phone. Okay? The material that is, it is just a material that will shield the waves, whatever, the signals from getting out. Okay? So that is what we call Faraday bag. So leave phones in there. Yeah. Yeah. No. You can buy it. You can buy it. It's not that it is only for law enforcement. No. No. You can buy it. It's available in the market. Okay. Faraday bag. So keep that in mind. Okay. All right. Let's go on. Also keep the digital evidence away from magnetic fields, because things like radio transmitters, car stereo magnets, because they can cause the static electricity, and your evidence might disappear. Okay? When you are transporting the evidence, make sure that it is you properly protect it. Okay? So that you don't have problem when you go to court. We talked about live data or live forensics versus post-mortem forensics. Here is where we're talking about, you go to a place, you get a computer which is on, and because you cannot pick that computer or you cannot pick that device, it forces you to ensure that you can pick the data while that computer is on. That is what we call the live data forensics. And post-mortem, I would say that if you find a computer is off, then you don't turn it on. You just make sure that you can remove the hard disk and image the hard disk, and then you can collect the data from there. And this is live forensics actually require a high level of specialism than the procedure that you use in search and seizure or dead box forensics. You need to have somebody who is actually has got knowledge to collect that data from the live forensics. So what are some of the volatile data that can disappear? Okay, when you shut down the computer, anything that was in the memory, like RAM, will disappear if the computer is off, is turned off. Something like unsaved document. If you are writing a a Word document that is it is not saved and the computer goes off, you might lose that in data. Running processes, when the computer is running, there are processes that are running. If you shut it down, it will those processes will actually disappear. Password and encryption keys. I gave you an example of these guys who operate the dark web, the sites like Silk Road, Alphabay. Now, these people, they make sure that their laptops have got encryption keys. So the moment you grab the laptop, they shut down the laptop, those the hard disk is encrypted and you can do nothing. So why you should make sure that you grab that laptop, or why FBI grabbed the laptop before they shut it down is that the possibility of the encryption key is in the RAM. Okay, so if you shut it down, you lose the encryption key. So you can actually find the encryption keys in the memory. Open network connection, logged on user, malware binaries. Malware is always stored in the memory. So if you want to analyze that malware, make sure that you don't shut down that computer, because the binaries for the malware binaries will also disappear. So what are requirements for live forensics? Specialists with this, specific training for live data forensics. You also need hands-on experience. You are a set of validated forensic tools for live data forensics. You need tools, specialized tools to collect data from the memory. If specialist is not available, then you can pull the plug rather than losing the data. Chain of custody, I think this one we looked at. Sorry, it's a repetition. We looked at just yesterday. Okay. Any question on that? That's mainly collecting, but this content is mainly for the investigators. Any question? Before we move to another presentation. Remember what we said? All this, you do the investigation, you collect your evidence, you process your evidence using forensic tools. Eventually, what you need to do is to write a report. And that report is what you are going, if you are an investigator, that report is what you are going to hand over to the prosecutor. So you need to write a good report, because that good report is what is going to make or break the case that you have you're having before you. Also, if you're a lawyer and the investigator has done his work, make sure you sit down with the investigator so that he can tell you, he can educate you. If you are not technology savvy, can educate you how they derived that evidence, how they extracted that evidence. It prevents a lot of embarrassment in court, because if you are talking your language and the expert witness or the expert is talking his own language, you cannot get to understand each other. So normally, when I go to court, I ensure that the attorney who actually hired me, if I do the investigation, we sit with him on the report. I need him to understand the report. From there, you can help him formulate the cross-examination questions from that report. Yeah. Mm-hmm.
So you say you sit with the judges?
Not judge. Your lawyer, the lawyer. You see, you are a defense lawyer. Okay. Let's say you are a defense lawyer. Okay. The prosecution has brought a report. Now that report, you will also, as a defense lawyer, you need to you are expert to go through that report so that you can understand. So the expert is going to help you understand the report and even help you formulate cross-examination questions. Yeah. So it is better to do this before you proceed to court. Because this happens, I gave you an example where I was an expert witness and we went to court in the morning. I handed over the report to the IO, and then the IO handed over the report to the defense lawyer. So during, this is when they prayed that the court should be adjourned for a later date. And the magistrate actually agreed to their prayer. So we came to court later in 2 weeks' time, thinking that this person had gone through the report. Okay, this person did not get somebody of an expert to go through the report and understand the report so that he could ask me questions which are relevant during cross-examination. So when I stood there, the guy, the defense attorney, instead of asking me questions related to the case, he started asking me questions like my qualification. He was telling me that he investigated my university and the degree that I was holding is not valid. I'm a quack. He told me a lot of things. But then what happened is that the prosecutor comes to your aid because he wants you to answer the way you want. And that's what happens with you lawyers. You want me to answer question they want you the way you want it, telling me, okay, why don't you just say yes so that we continue? I say, no, I can't not say what is not right. So you just be adamant, and later on the prosecutor will actually help you. There's also another case, a case where I was an expert witness and I was examined by my attorney. But when it came again now to cross-examination, the magistrate asked the prosecutor, do you have any question for the expert? The prosecutor just said, no, I don't have, because there's nothing she could have asked me. So this tells you that this is a gray area. It's a gray area. There are few experts in this. So what you need to do is to work closely with the investigator, the person who investigated, the person who is going to present that report in the court of law. Work with him. If you're in on the prosecution, work with him. If you're on the defense, work with him. That is going to help you a lot of help you with a lot of embarrassment in court. So let's see forensic analysis and reporting. What does a computer forensic report look like? How does it look like? Computer forensics report provides a detailed information on complete computer forensics investigation process. What did you do? This is what tells you everything that you did from the time you collected the evidence from the crime scene to the time the evidence is brought to court. So it should be submitted in a timely manner. It should be able to explain how the incident occurred. The report should also be technically sound and clear to understand. You should not write jargons. Remember, you are writing this report for a prosecutor who is not a technical person. This report can also be available for the judge. They are not technical people. They are expert in their own area. So you need to talk to them in a language that they understand. Be properly formatted with page and paragraph numbers. Be professional in your reports. Don't just write reports which are not really looking professional. Provide an ambiguous conclusion, opinions, and recommendations supported by figures and facts. Remember, you are an expert witness because the trial of fact or the judge depends on your expert opinions. So your opinions must come very clear on that report. Adhere to the local laws of the land and to be admissible in court. When you are writing your report, you have to consider what are the laws that you need to take into consideration. For example, in Kenya, when I'm doing my report, I know very well that I need to check the Evidence Act. And what does the Evidence Act say about digital forensics report? Okay, how do I need? What do I need to have in place to present it? So if I put my report, I must make sure that my report have attached the certificate according to Section 106B of the Act. So you need to look at to observe the laws of the land for that report to be admissible. So, what are salient features of a good report? They truly define the details of an incident. How was the incident? How the incident occurred? Clear and understandable to decision makers. Remember, decision makers here is the trial of fact or the prosecutor who needs to consume this report. So they need to understand it. Yeah. Okay.
On the other side, on the report, try to know if this expert must have a minimum skills on the laws. Suppose that is an IT expert which has not skills in laws when he's going to report on a case.
No, there's nothing to do with law. There's something to do with the investigation that the expert did. Okay, but that's why when I talk about the laws of the land, which means that as an expert, you need to know that, for example, myself in Kenya, I'm not a lawyer, okay? But if I'm writing a forensic report to present it, what does the law say? There's an act. Remember what we say that this depends on from jurisdiction to jurisdiction, and digital evidence must be collected according to the laws of the land. So before you present this report, what does the law say? Okay, and this does not mean that you have to be a lawyer. You just know like Evidence Act, yeah, especially the Evidence Act. What does the Evidence Act say about a forensic report? How do you need to present it? Okay, that is all that you need. You don't need to be a lawyer to do this. Okay. Okay.
And about the technical words and jargons.
Yes.
Because we mostly see some, even though it's not in this domain, we mostly see the report, medical report.
Yes.
And we see most of the time the courts, those reports are written in the jargons. And so somehow difficult to explain.
I understand. I understand from where you're coming. You see, there are certain things that you may not be able to explain on the report. You'll have to use technical terms if there's no any simple language that you are using. But that is why you go to present that report as an expert witness, so that when you are given the chance to present it, you are able to explain those technical terms in simple language that the court will be able to understand when you are presenting that report. You see, you cannot do a report and then somebody goes to present it for you. You need to go and present it yourself as an expert witness. Okay? So you'll get a chance to explain what people were not understanding in that particular report. The report should be easily referenced and contain all information required to explain the conclusion, and it should be created in a timely manner. Again, aspects of a good report. A good report achieves the purpose by answering questions that were set out in the mandate for investigators. By the time you are doing what? You are given the job to do the investigation. You have a mandate. And that report must be able to answer the mandate properly. It is designed to meet the needs of the decision makers. then a decision maker must rely on the facts that were presented in the report. That report should be everything about that investigation that you are doing. And the fact must be based on evidence in the file, and it must be written in a clear and written in neutral language so that the decision maker and other readers may be able to understand it. As much as possible, try to see that your report is written in a neutral language. Then it should be concise and must convey the necessary information, and it should be structured in a way so that information can easily be located. I think we've just summarized that. You have the executive summary of the report, the objective of the investigation, date and time of the incident occurred, date and time the incident was reported to the personnel, agency personnel, name of the persons reporting the incident. So these are some of the topics that you'll be able to explain in the report, just to ensure that your report is comprehensive. These are templates that you can use to create your report. So report classification, we can have a verbal formal report. This is a structured verbal report delivered under oath to a board of directors or managers or a panel of jury. Okay? You can have verbal informal report. That is a report that is less structured than a formal report and is delivered in person, usually at the attorney's office. Then we have written formal report. This is a written report sworn under oath, and such as affidavit or declaration. And then we have a written informal report, that is an informal or preliminary report, which is in a written form. So these are some of the kind of report, classification of reports that you might have. How do you lay it out? Choose a proper layout and presentation for the report to maintain consistency. Just ensure that it is properly laid out. Include signposts in the report to clearly communicate the information and to draw the reader's attention to a point. You can also choose the numbering structure for the layouts systems. For example, you can use the decimal numbering system or legal sequential numbering system. Include tables, you include data, include equations in the report, and then also include data collection, how you collected that data. Remember, your report should be a very complete one, one that will be able to, somebody reads and makes a decision out of it. Maintain proper document style throughout the text. You need to keep a copy of that report because you are also going to represent that report in the court of law. Usually you do this on you PDF them. Do not file a report directly with the court. Okay? I don't know. This now depends on each and every jurisdictions. Definition of goal or mission of then is necessary. Why you are actually doing that investigation. Order of writing should match the development of the case. Don't just write haphazardly. Make sure that you are writing which that matches the development of the case. Use outline or arrangement is suggested. That's the guideline. We've talked about avoid jargons. Write something on simple, neutral language. Define any acronyms and abbreviation if you're using them in the report. Make sure that they are defined. Check grammar, vocabulary, and punctuation and spelling. This is very important. Write a report which can be understood by your audience. You must make sure that you check the grammar. There are tools which you can install on your computer which checks the grammar, and especially when when you are writing academic article, you need to make sure that the grammar is proper, and that also the same thing when you're doing a report like this. Write a report in a concise manner. Do not make any assumptions. Just write the facts. Lay out the ideas in a logical manner. Double check your media's findings. Write a theoretical question based on factual evidence and support your report. A report must support your opinion. You know, as an expert, you're giving your opinion to the court here. And the court has allowed you to give your opinion because you have an expertise in the area that court does not understand, do not have the expertise. So you are allowed to come in and explain to the court, educate the court. Most of this time, most of the time you become an educator to the court. And write opinion based on knowledge and experience. Use supporting materials. If there's any supporting materials you have, you need to use those ones. Use figures, tables, data, and equations as supporting materials. Number figures and tables in the same order as they are introduced into the report, and insert figures and tables after the paragraphs and give a proper numbering. Also provide captions with complete information. So this is just using of supporting materials on your report. Why is consistency important in a forensic report? One, consistency is more important than the exact format in the report to eliminate uncertainty and confusion. Also, the section in the report format must be adjusted in the same way, and establish a template for writing reports and highlighting the main points. So you can create a template that you can use for this report. You also need to, if there's attachment and appendices, you need to take into consideration. Use attachments and appendices as supplements to the report. Attachment and appendices can be used to further detail any terminology, any findings, or any recommendations. And also, you must make sure that you can provide reference to attachments or appendices when report has more content. Include metadata. Yesterday, we talked metadata. Okay. If it's a picture, for example, make sure that you include the date that picture was taken, you include the location, you include the name of that file, you need to include that. Metadata is information about file, including the who created it and the time and date stamp. And the significance of metadata is based on the properties of the file. Two types of metadata can be, in a forensic report, can be system metadata, which you can use to identify the change or in file location, or application metadata, which can be used to identify the change in document author, document version, and things like that. What are some of the investigation procedures? General evidence. You need to put the date and time the investigator visited the site of the incident, the person with whom the investigator spoke at the site, and you need to include collecting physical and demonstrative evidence and collecting testimonial evidence if that is allowed. Collecting physical and demonstrative evidence. The manner in which the scene of incident, if any, was secured. Remember when we were looking at securing the scene, when we are looking at the introduction to digital forensic, just the normal way you secure, let's say, a murder scene, the same way you'll be able to secure a digital forensic investigation scene when you go to the crime scene. Okay? List each piece of physical evidence that was collected. So if you collected 5 computers, you list them. if you were collected 2 mobile phones, you have to list them. The manner in which the physical evidence was presented after, preserved after the collection to maintain the chain of custody. We've talked about chain of custody a lot since yesterday. So that chain of custody must not be broken. You have to ensure that it is maintained from the time you collect the evidence until the evidence is brought to court. A list of the other demonstrative evidence available to the investigation, e.g. diagrams, maps, floor plans, you need to include those ones. A list of pictures that were taken, you need to include them, plus their metadata, and the manner in which the physical evidence was collected and logged. So these are things that you need to include in your report. What are the do's and don'ts of computer forensics investigation? Ask, yes, when you go to a crime scene. Document thoroughly. We say that documentation is what is going to help you convince the court that this evidence that I'm presenting has not changed since I took it from the scene. Operate in good faith. Do not get over your head. Okay? Make the decision to investigate and treat everything as confidential. Confidentiality matters depending on the case that you are handling. File the documents properly. Best practices for investigators. Before submitting the report, read it again so that it gives you a clear view where you need to make changes. Proofread it. While revising the report, ensure that it is coherent, not repetitive, and present information in the right places. Okay? Also, make sure that the report corresponds to the mandates, and anyone new to the situation must be able to understand the report. So those are some of the best practices as an investigator so that your report is clearly understood. Sample forensic reports. So you can see from investigation, concise summary of conclusions. You put your observations and all your appropriate recommendations. That is all you need in a report. So the report identifies the continuity of information and describes the procedures utilized during the investigation. So these are some of the sample reports here. You can see the objective of the objective of the investigation, the computer type that was being investigated, what was the operating system on that computer, what was the offense that you are investigating, like possession of child pornography, the case agent who is in charge of the case, evidence number, chain of custody. You need to attach the chain of custody to the report, where examination took place, and then tools that we use to collect the evidence. And this is the body of the report. So this is just a sample report that you could use, you can adopt when you're doing the report. Some report number 2, just same, you can see the memorandum, the subject, the status, the summary of findings. Okay? The item analyzed. You can see the serial number, the description, and then details of their finding. So this also, the objective you can see is the computer type, just like the first report. Another report here, where here it starts with analysis and then it goes to findings, okay, of the findings. Okay? And then sample number 5, It starts with documentation, then goes to summary of the report, and then it goes to conclusion. So it does not really, there's no format that you, or a template. You can come up with your own template when you're doing this report, okay? Any question? I saved it. I wanted just to show you a report that I did recently for after an investigation. But I seem to. I don't know. I don't know why. I saved it as this. In the meantime, any question? Before we move to our last session. This is just an example of forensic analysis report that I did. You can see there it is expert's background and experience, investigative narrative, forensic analysis report, a process, analysis of and key findings of the client, forensics tools that were used, remote access to what's happening to this thing, remote access to a plaintiff's MacBook. So this is just an example. And then here you can see I include here as per the law the certificate. Okay, the certificate shows the computer data I was using to do this report. I put all the details, and I say I'm the authorized owner. Wow. So this is just one of the reports. Let me just see if I can get another most. Okay. My findings, digital investigation and the findings. Document forensic analysis and the conclusion. Then, as I said, you have an annexes that you put on the report. Okay, this is a different report. Let me see if there's any other report here. I think those are the samples that I have for now. Preliminary forensic report. The investigative narrative, you can see which machine, which computer I was analyzing, their model, the serial number, mobile phone, the model and serial number, and also I was also analyzing the Facebook account of this particular suspect. And what is the objective of the forensic investigation here was to extract contents of the laptop, proving that the laptop belongs to the suspect, to extract the WhatsApp chats from a mobile phone of the suspect, and to preserve Facebook pages of the account of the suspect. So if you look at all my CV, sorry, I don't. Let me just. This is not the detail. This is a summary of the report, but I wanted to show you preliminary analysis. So, for example, you see, this is a Facebook report. This is an exhibit, and you can see this Facebook page. Then on that Facebook page, I've preserved it, and you can see I have the MD hash, the hash value, the MD5 hash value. I also have the SHA-1 hash value, which means that if you go to this page and the suspect goes back to this page and changes something, then the hash value is going to change. And I can go to court and I say, when I preserved this page, this was the hash value. Now what he is bringing into court has changed, which means that this he has changed something on there. So immediately I went to do this investigation. I needed to make sure that I hash each and every page that I was investigating, so that I can maintain the integrity of that that page. Should something happen, yes, there's my CV. I need to attach the CV. These are the exhibits that I was given. And this is, I was talking about this evidence handling form. And before that, this is the chain of custody. Request form. All these form are part and parcel of the chain of custody, so that I know that when I take my report to court, it's not going to be dismissed. It's going to be accepted. Any question? Yeah.
Thank you very much for a very insightful presentation. I would like to know the place of, in your investigations or any investigators, as we've been discussing, do you have any place for exculpatory evidence? Like in the report that you have, because sometimes the defense lawyer might even not be able to access those kind of information, which as a forensic person would be accessing as you are examining maybe the devices or whatever. So you come to exculpatory evidence. Usually it would be, it is even required in our laws that investigators would also present it. We would like to hear from you on that part.
Just come again. I didn't hear it properly.
Okay, well, I'm talking of exculpatory evidence, which is opposed to those that accuses. And in the report we've been discussing, or even collection and processing of evidence, we did not have part on that on that side of evidence.
Yeah, just explain to me the what?
Good. These
I'm not a
are
lawyer.
evidence that prove the person to be innocent, like opposed to accusing the person, the suspect. You might be having someone's phone, and in some of the texts you come to some text that can exculpate him or her, that can make him or her a witness. Not to be suspected as such. Yes.
Not to be a suspect. Yeah, I remember when I talked about an investigator and a suspect, an expert witness. And we are going to look at this right now. When you are doing your investigation and you are going to present your report in court, you have to write exactly what you got. If it is something that, if you did not get anything, then don't implicate that person. Just don't look at the person who pays you and then write a report according to his instruction. As an expert, you need to just write what you got, and whatever you got, maybe if they didn't get any evidence, then you see this guy is not cannot be prosecuted.
That's very good. I just wanted to know if you also have a focus on it, like, because we've been having these issues that investigators are only focusing on evidence that accuse the suspect instead of even looking on the other side. So that's why I had to bring it up.
No, then you are not an expert, because if you are trying to implicate somebody, let's see what an expert is. So we are going to look at the expert witness and court hearing.
Excuse me.
Yeah, okay.
Thank you. These days we've seen there are other emerging world where people can go and live digitally. the digital world, like the metaverse, the meta world, from your experience as a digital forensic researcher, maybe in that what? Have you ever met such a maybe like a crime committed and then you need to research about that world, that virtual world? How do you come to get the evidences? If any could happen, how would someone as like an expert would try to investigate and do research about that world? Thank you.
Yeah. I've not experienced that as at now. But what I can say is this: you are doing an investigation depending on the device from which you want to extract that evidence. Okay, so if it's a meta world, there's a process of investigating that particular environment. So the thing is that if it comes my way, then I need to research on how I'm going to do the investigation in that particular scenario. But as I say, we are in the world of internet of everything. Okay, anything that has got some sort of intelligence in it, which can connect to the internet, will have data in it. So, for example, if you look at the electric vehicle or a driverless cars, okay, there's data that it's being stored, and that data, there's a way to extract it. Okay, not using the normal forensic way, but there's a process of making sure that you get the data that you are looking. Just the same as an aircraft is a flying bomb. It is all computerized. We have the autopilot. Okay, if there's a problem, if there's an air crash, then you need to investigate. See, these experts will be able to extract the data, let's say from the black box. Okay, there's a process of doing that. So it will depend on the scenario in which you encounter. Then you'll have to do maybe a research on how to extract data or evidence from that environment.
Yes, sir. Earlier you mentioned that when I go to a crime scene and I find a computer learning, I should not shut it down, because once you do, the data is completely lost.
Yes, the
But
data in the RAM.
yes,
in the
yes,
memory.
the data in the RAM.
Yes.
But again, if I intentionally delete my data on the computer, it can be retrieved anytime. So do you please enlighten me about the difference?
The random access memory is a place where if you switch on your computer, nowadays it doesn't count, but the computer will have the place to store the hard disk, the files on your hard disk. For example, if today you create a Word file and you say it's file save, it saves in the hard disk. Okay, now that is a permanent file which is on the hard disk. Now, when you switch on your computer, whatever you're doing in your computer, for computer to communicate with itself, it has to put whatever is current, the data that is current, it's put in the RAM, random access memory. The processes that it's running, the files that you've opened, they will be in the random access memory. So what is in the random access memory is temporary. Okay, when you shut down that computer, then everything that was in the random access memory disappears. Okay, now when I said you can retrieve, you cannot retrieve something which was in random access memory when the computer went off. Whatever is in the hard disk is what you can be able to retrieve, because it is in the hard disk. So if you delete it, remember you have permanently saved it in the hard disk. If you delete it, that is when I said the operating system tells itself that that place is empty. If I get another file, I can write it there. Because from the table of contents, it said it was in page 4, but that page 4 now is free. So it gets another file and overwrites that, and depending on the size of that file, okay? If the file that was deleted was bigger than the one which you are bringing, remember it's going to write part of that space, but the other space is going to remain so that you'll have maybe those what we call artifacts or slack spaces, okay? Yeah, so there's difference between the permanent storage, which is actually in the hard disk, and the temporary storage that is in the random access memory. Whatever is in random access memory, you shut down the computer, you won't be able to get it. And I mentioned also this drag loads from the dark web. Okay, there I'll show you the dark web after this. Whatever they have, whatever their PCs or laptops are always encrypted. Whatever, if you shut it down, then that encryption key, you won't be able to get it. And that is the reason why I told you FBI always make sure that they grab that laptop while it is on. Okay. Yes.
Thank you. This is from maybe experience. I would like to know much about it. From your presentation, you've shown, even starting from yesterday, you showed us different electronic devices that may be used: computers, telephones, and other electronic materials. But when we go to the laws of this law on cybercrime, they say computers. And from the experience, what we had, when they go to define computer, they also include those smartphones and other electronic devices. Then it caused conflict and maybe one failed to understand, if I use this telephone, should it be taken as a computer? Maybe that we say that it is a telephone that is different from a computer. Then it becomes more complicated when you go to practice to differentiate between a computer and a smartphone and other electronic devices. And even from your presentations, you could present them in different way. But when you go to the cybercrime law, you find they use the word computer. In Kinyarwanda, they say mudasobwa. When they go to define the word mudasobwa, then they define it in a computer way. Then how could we differentiate those electronic materials that would be used, maybe in committing crime, in doing research, and all those? Thank you.
Even a telephone, even a mobile phone is a computer. Yeah, it's a computer. It is given the term mobile phone, but it's a computer. Yeah. So when you talk about computer, you're talking about anything that has got intelligence in it. Even a watch, provided that there's intelligence in it, it has got a memory, it has got a storage, it has got the what do you call it, the brain of the computer. It is a computer. Okay. So everything, when the law says computer, is computer. However, they must differentiate in terms of presenting that evidence. Okay. For example, our law is very clear in the evidence law, in the Evidence Act in Kenya. It's very clear. Section 78A tells you how to present evidence from things like WhatsApp, texts, and the rights. Section, I think 104 or 106 tells you how you should present evidence from a computer system. They are very clear. So the law must be very clear, but everything is taken as a computer. So when it comes to digital forensics, what I say? Digital forensics categorizes different types of devices, because the way the process that you use to extract data from a computer is not the same process, not the same methodology that you use for forensic mobile phones. The tools are different. Okay, the tools are different. So you can see that in digital forensics, this is how it is divided. First of all, we have computers, because computers were actually the first devices which had data when people forensics started. So you can see that I have a computer forensics, where I have the postmortem. Remember what I said? Postmortem or dead box means that the device you are investigating is off. Okay, it is off. So you don't need to put it on. Then we had live forensics, when the device is on and you don't have to put it off, because you are going to lose the data in the RAM. Okay. And then we have multimedia forensics. On the other hand, we have mobile forensics. This is now the classes of the phone. Okay. Be it smartphone, be it any phone will fall under mobile forensics. When you are investigating network forensics is whereby, you see, you are communicating within the network, or there's a communication between this my mobile phone to the cell tower to the service provider. I might need to extract evidence from that channel of communication, and that is what we call the network forensics, whereby you can be able to sniff the data and be able to analyze that data. And then we have the embedded forensics. This is where we have everything of the internet of things, internet of everything. This is where we have driverless vehicles. We have electric vehicles. All this, they have data. So the process of extracting data from each and every category of this group will be different. Okay, but provided that you use the right tools to extract the data. Okay. Wait, another question before we move to our last session today? Do you have another question? Yes.
Thank you. I am Pascal from Sanram Assurance General. My question is
speak up.
Like, my question is on what you presented yesterday. We've seen that for the admissibility of the digital evidence, it requires relevance, which simply means that it has to establish the linkage between the perpetrator and the crime scene. And my question is, what do we consider to be a crime scene in cyber crimes?
A crime scene is actually where the evidence or the device was existing. That device, you did not have it. You had to go somewhere and pick it. This is where this, let's say, the suspect is on this table. Okay. So I need to do investigation and find out where is the digital evidence that I'm looking. So I'll come and pick all your phones. Okay. So that is the crime scene. That's what it's treated as, the crime scene. Yeah. Another question? Another concern? Ladies, yeah.
Thank you. It's not a question. I wanted to clarify that actually the definition of a computer under the cyber crimes law, it does include mobile phones and smartphones. It says It includes any type of computer device, including devices with data processing capabilities like mobile phones, smartphones, etc., and other devices connected to the internet. So I just wanted to make that clarification.
Yeah, exactly. What processes data is classified as computer. Do you proceed? So you've written your report. In Kenya, I don't know, I found that it's a little, the rules of evidence is a little bit different in Rwanda, whereby the rules of evidence can actually supersede the scientific process. Is weird to see that somebody does the investigation and then somebody picks that and go and present it. I'm just wondering how you can present a technical report which you did not write. But in Kenya, if I do the investigation, I'm actually the person to go to court to present that before the court, okay? Because I'm the expert witness. So this is what an expert witness is. So let's look at the learning objective here. We are going to look at, discuss the role of digital forensic expert in judicial process and how they can assist the trier of fact in understanding complex scientific and technical issues around digital forensic process. Remember that you are the expert because the court does not understand this process. So you are going to there to educate them. And I told you a case whereby I went and I had to carry a projector because our courts are not designed to accommodate these new technologies. So the only way I could explain, I could not explain verbally. So I had to go court and make a presentation to court so that I can educate the court why whatever I was presenting is actually important. So, yes. Where's the...
Yeah, if the defense party doesn't believe in the report, is it possible to call another expert to challenge your report? Is it possible?
Yeah, it is possible because where the defense, remember what we talked about auditability and ensuring that you don't work on the original evidence. If you are not satisfied, you can make a prayer that you bring your own expert to look at the report. If the prosecution has done the report, look at the report and advise you. Or you can pray that you are given the device so that you can do your own investigation to see if you are arriving at the same result. You are allowed to do that. And that is exactly what I'm telling you. The case that I was done by a prosecution, and when the defense lawyer was given the report, he shared the report with me, plus the video. And he said, what is your opinion on the report? So I went there to rebut the report, okay, as an expert witness. Yeah, it happens very many times. We're also going to discuss the forensically validated court cases that have set significant relevance as pertaining to expert in their testimonies. There are some cases that have shaped the world of expert testimony. Explain the principles for presentation of digital evidence in court, and discuss the criteria for evaluating admissibility of digital evidence. Part of it we saw this yesterday, and outline presentation aids which may help to present the digital evidence in court. Just as I say, our courts are not designed for this technology. We are used to those courts where we sit on benches and listen to. When somebody wants now to scientifically present and educate the court, we don't have that setup. And that is why there's a presentation that I gave when we were launching our cybersecurity strategy. And one of them was having a special cybercrime court, okay? Well equipped so that you can be able to get this visual aids to present your evidence, because it is very difficult. As we talk, it's very difficult to explain technical things verbally. You need some visual aids. Who is an expert witness? An expert witness is a witness qualified by knowledge, skill, experience, training, or education that can provide scientific, technical, or other specialized opinion on a fact issue. Is somebody who is technically qualified. So an expert witness is not only going to be found in the forensic world only. We have doctors. Doctors can also always be called. We have engineers who can always be called to give their expert testimony regarding, let's say, if it's a building and there's a case, they can be called. So, as such, the role of an expert witness is to assist the court to understand the evidence before it determines the fact in issue. That is your work. You make the court understand. They do so by giving their opinions on matters that are foreign to the court. Okay? And they must tell the truth derived from their special knowledge. Now, this answers my colleague's question that when you're, can you bring evidence that is exonerating a suspect? Yes. It's not a matter that you are, when you're doing your investigation, you are targeting the suspect to only the evidence that incriminating them. You do your report impartially to ensure that if there's no evidence, you say there's no evidence. Because the court, you must derive the truth from your special knowledge. Qualification of an expert witness. The issue of qualification of an expert witness has raised controversy as to whether academic qualification or practical acquaintance can render one as an expert. Now, in our country, this is a case which was determined. So this case was Gaderu versus and Jaragua versus Republic. It was observed that expert skill is not confined to knowledge acquired academically, okay? But would also include skills acquired by practical experience. So your academic certificate does not really matter when you talk about expert witness. Now, the example here is a given that a police officer employed on operational investigation work acquires sufficient practical knowledge so as to qualify him to speak as an expert witness. Okay, so it is not only academic qualification, but provided you've been working in this field for a long time, you can still be an expert witness. The only thing that nowadays that most of the courts will insist on academic qualification. Know that you formally went and did that training. Key qualities of credible expert witness: perform thorough investigation. When you are coming to present something, it is something that you really had performed a thorough investigation. Because remember, sometimes you are going to be an expert witness and you are going to put somebody in for life. So it is not good that you do a shoddy work. Make sure that you perform a thorough investigation. Demonstrate effective teaching ability. When you go to court, remember there are certain, I said that way, you try as much as possible for your report to be clearly understandable by the layman. But sometimes you might find that the technical terms that you can't avoid them. And that is why you are going to court. And when you do go to court, you now try to explain these terms. Yeah? You explain this time to court, to the court, so that they can be able to understand you. Yeah? You need to be competent. These are kind of work that you can't just do without, if you're not a competent person. You need to be believable. You need to persuade users of factual accuracy without advocacy. And you need to demonstrate enthusiasm and preparedness. Those are the qualities. Rules of expert testimony. These are varying from jurisdiction to jurisdiction. An expert witness, as an expert witness, you are expected to know the rules of evidence. You are evidence pertaining to expert testimony for the jurisdiction in which you will be testifying. The general rule of practice is that expert witness should be given priority over other witnesses. And that is why you are given a chance to stand there, be sworn, and then start educating the court on your report. The evidence of such witnesses may be challenged by other witnesses. This is exactly one of the people asking. If you feel that the other expert witness has given his report, and the report is shared with you, your work is to rebut that report. You can challenge that report for your side to get the leeway. So this is very important for defense. Always don't just accept just easily. Try, if these guys share the report with you, try and get an expert witness, an expert to look at that report and advise you and formulate those cross-examination questions so that you can be able to challenge the other party or the other expert. Testimony of an expert witness. A witness who is qualified as an expert by knowledge, skills, experience, training, or education may testify in the form of an opinion or otherwise. If the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine the fact in issue. That is your work. You are not, in fact, you are, as an expert witness, you are not coming to tell the judge what to do. You want just judge to use your opinion to deliberate on the case, okay? Or to adjudicate on the case. But it is not you to advise them to what to do. So you give your opinion on the investigation that you did, how you did it, and why I think it is important. You don't side with any party. The testimony is based on sufficient facts or data. Testimony is the product of reliable principles and methods. So that's why forensic expert falls under expert witness, because your testimony or the product is of reliable principles and method, and the expert has reliably applied the principles and methods to the fact of the case. Yeah. Now, there are some cases that actually shaped the world of expert witness. This is Pryor versus US in 1923. This was known as the first use of polygraph tests, the lying detector test. Okay? And it's one of the relevant, one of the landmark cases held remarkable, relevant over the judicial forensics. So the defendant, which was Fry, was convicted of second-degree murder and argued on appeal that the trial erred by refusing to allow expert witness to testify about the result of systolic blood pressure deception test taken by the defendant. Now, this is when the systolic pressure, of systolic blood detection was being invented. So this guy, actually, he murdered somebody. And then when he was taken to court, he refused the case. Okay, so the guy who was the doctor who had invented the systolic blood pressure offered to be an expert witness by going to court and trying to doing what? How do you measure whether somebody is lying or not? The lying detector. He used it on this person to see that this person lied. He was not the murderer. He was not actually the murderer. He lied to the court that he had murdered because he wanted to be paid some money. Okay, so this guy said that he offered to be an expert witness because he went to court and measured this guy and found that the guy had lied. Okay, so the court when he wanted to be the expert witness, the court refused. The court refused that and excluded it. And when they went to Court of Appeal, the Court of Appeal of District of Columbia affirmed the conviction. It was held that the testimony about systolic blood pressure test was properly excluded. They was not allowed to be an expert witness in this case because it had not gained the required standing scientific recognition from psychological and physiological community. Yeah, community, which means that the systolic blood test was a new thing, and the court would not rely on that test because this thing had not been recognized by the experts in that particular area. Okay, so the court held that expert testimony must be based on scientific principles that are generally accepted in the field of expertise. So these guys in this field of expertise, they should have recognized the systolic blood test as something that it can be universally, it can be generally accepted within that expert area. So in its decision, the court stated, while courts will go a long way in admitting expert testimony deduced from a well-recognized scientific principle or discovery, the thing from which the deduction is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs. So the court established that it was what is known as the Fryer standard. This was the Fryer standard in 2023, but it has been replaced by Dubert standard. Okay? So this is a case that actually shaped the expert testimony. And why? Because the court refused that this systolic blood test had not been generally accepted by the community, the expert community in that area. So it could not be included in as this guy could not be included as an expert witness. So they appealed, and when they appealed, the High Court still upheld the conviction. Okay? So this is what we call the Frye standard. It's one of the cases that has shaped how the expert witness testimony. But it has now been replaced by Dubert standard. So Dubert standard was in 1993. So the issue in the trial was whether a prescription drug manufactured by the defendant had caused serious birth defects in children born to women who had used the drug. So this Merrill Doe was the manufacturer, was the defendant. Now they had manufactured a pill that women were taking in the morning, the pregnant women. So what happened is that Dubert claimed that those who took that drug actually gave birth to defective children. So Dubert went to court and shoot the Merrill Doe. Okay, so both sides called the series of physicians to testify as scientific expert on the question of causation. In concluding that the trial had improperly excluded testimony offered by the plaintiffs because it had been based on test tube animals. So, which means that the plaintiffs, both sides brought expert, just as you say, when the judge decides that you go and bring your expert, that also brings their expert. So you find that the plaintiffs, they brought their expert, but their evidence was not included because when they did their tests were based on the test tube and animal studies, okay, not on human being. So the Supreme Court set forth some criteria that trial courts must evaluate in deciding whether or not to admit an expert testimony. And this is why I think this is the same here in Rwanda, where the judge becomes the gatekeeper, okay, to decide whether that expert testimony should be admitted or not, or should you go and get another expert. The court held that trial judges should be the gatekeepers when it comes to determining whether an expert testimony is scientifically valid. The judge in a case must consider the following 4 factors when determining whether to allow expert testimony. Okay? 1, whether the theory used is based on scientific or other specialized knowledge that has been or can be tested. So when you talk about digital forensics, is it scientific? Has it been tested? Okay? Another thing is whether the theory used has been subjected to peer review. Digital forensic has been subjected to this. The known or potential rate of error and the existence of standards controlling the theory's operation, and the extent to which the theory is generally accepted in that particular community, in the scientific community. So you can see in the relevant community. So you can see these are the 4 factors that the judge will use to determine whether you as an expert witness will allow your testimony or you will not allow your testimony. So here, the Dubat standard just establishes the judge as the gatekeeper, which I think is a good thing. Even in Rwanda, according to our discussion yesterday, the judge is actually the gatekeeper who will decide whether I'm going to allow this expert witness to testify or I'm not going to allow. Or I'll tell them to call each and every party to call their expert witnesses. So the Dubat case established what is known the Dubat standard. The Dubat standard is the test currently used in federal courts and in most state courts. It concluded that scientific expert testimony must be based on sufficient facts or data and be product of reliable principles and methods. That is why, as a forensic, digital forensic investigator, you qualify as an expert witness in digital forensic cases. What are the roles, expert roles? The role of an expert varies, and there are many roles an expert can play in judicial proceeding. An expert can be retained to review the forensic case document to the retaining counsel through the discovery process and to determine the following. Was the forensic analysis done properly? And that is why when you get a case and you want to rebut that case, you call another expert witness. He will look at, was that forensic analysis done properly? Or did it follow the standard? Can the forensic process be repeated, and can the forensic results be duplicated? Something like, is the examiner that performed forensic analysis qualified to do that? Okay? Do the forensic findings support the claims made by the opposite opposing counsel. So these are some of the things that forensic expert, digital forensic expert, can help the court or the retaining counsel. Additionally, a forensic consultant will often help retaining counsel prepare cross-examination questions for the opposing counsel witness, and they will usually be in court to listen to the opposing counsel expert. This is what you expect. If I'm an expert witness, I'll go with you to the court, and when that person is giving a testimony, I listen very carefully, so that after this I'll help you formulate the question for that witness. So the questions that are relevant to what he's talking about. Yeah. Should opposing counsel's expert testify to something that is misleading or inaccurate, the forensic consultant can be called to rebut the other expert's testimony. Okay. That is, I've done it and I've succeeded. We have succeeded. The guy was acquitted because of the shoddy work that was done by the prosecution and the kind of report that they gave. Well, after I rebutted that report, in the deliberation, the client was actually acquitted. An expert may also provide technical explanation to retaining counsel, a judge, with regard to forensic analysis and procedures. In this role, as a teacher and technician, the expert will walk the interested parties through many of the complexity associated with forensic analysis. Now, expert will often face highly technical questions when testifying, and it is paramount experts receive up-to-date training in their areas of expertise, as they run risk of being challenged if they use outdated techniques and have been proven unreliable. Sometimes you can, if you don't actually update your knowledge, you can be embarrassed in the court. Experts should also stay current with the emerging trends in their field. Now, expert witness duty should always to be the truth and not the individual paying them. That's why your report must be impartial. They should always offer objective opinions and conclusions that are supported by facts and facts alone. Okay? An expert witness should never offer an opinion or conclusion in court if they have not performed proper examination of the evidence. Presentation principles. Now, this is where we're saying that our courts were not designed for such kind of evidence presentation. After evidence has been found in the analysis state, the examiner needs to create a report for the trial. We've seen how the report is being created. An examiner's job is to illustrate and translate complicated technical facts that judges, prosecutors, and parties can easily understand. We've talked about that in the report. They may also be expected to interpret those facts and express an opinion on their meaning. That's why you go there to stand before the court, and if there's something is technical, you need to explain to the court. Clear, understandable language should be used to facilitate understanding for non-technical audience. So the report and the presentation of findings in court shall form a testimony in a court proceeding. The information and the way they are presented can impact the admissibility of the evidence. So that is why I'm saying, whatever you're talking, the judge or the magistrate is really listening to your opinion, and your opinion is going to make them do the correct judgment. It can also impact the court decision in proving guilt or innocence of a person. We talked about this criteria for evaluating of digital admissibility of evidence. We talked of the authenticity yesterday. The evidence must establish facts in the way that they cannot be disputed and is representative of the original state. completeness, the analysis, and or any opinion based on the evidence must tell the whole truth, the whole story, and not be tailored to match a more favorable or desired perspective. A whole truth. Your analysis and your opinion should only tell the truth, not tailored to match the more favorable perspective. Proportionality. The methods used to gather evidence must be fair and proportionate to the interest of justice and caused by the rights and any party should not weigh the probative value of the evidence. I think that's self-explanatory. Convincible. The evidence must be persuasive as to the fact it represents, and finders of fact in the court process must be able to rely on the evidence. Reliability we talked about yesterday. There must be nothing on the way in which the evidence was collected and subsequently handled that may cast doubt on its authenticity or veracity. So your evidence must meet all these criteria for it to be admissible in the court of law. A best practice, even though we've looked at this in the last presentation, tips for presenting findings in court. You cannot say just the suspect visited the website and downloaded an illegal material. See, when did he visit the site? What illegal material? So if you can say, with this computer, which means that is the computer which has got which is the X-bit, at this point of time, using the user accounts suspect, the Firefox browser was started, the website has been visited, and 16 illegal files have been downloaded before they were moved to the home folder of the user suspect. 2 minutes before that, the password protected webmail or account suspect at gmail.com has been accessed via Firefox browser and 4 minutes after that, private online banking account of the suspect has been accessed by the same browser. You see, that statement is very complete. It gives you all the facts that you are looking for. Presentation aids. As the nature of digital evidence is mostly technical, it's not easy to present this evidence to a non-technical audience, as described before. You can't explain these things verbally. So it is recommended that the expert use as many presentation aids as possible and feasible to facilitate understanding on complex findings. I think this we've just seen on the report presentation, how you should use all this. Some courts and judges allow usage of alternative presentation methods, while others may not, depending on the jurisdictions of that case. Discuss this possibility with the judge before the hearing. So you need to discuss whether you are going to, you tell that I'm going to use a projector here, I'm going to use some visual aid to try to explain these facts to the court. So these are some of the things that you can use. We show this in the last presentation on the report analysis. You can use pictures, you can use videos, you can use graphs, you can use virtual machines, you can use 3D scenes, okay, to present your report in the court of law. Forfeiture and recovery. Most jurisdictions allow forfeiture of digital evidence in case that the items have been used to commit a crime. So you have to forfeit that. I don't know what happens in Rwanda, but something like if you are doing an investigation involving cryptocurrency, okay, and then what happens is that you need to surrender that cryptocurrency, you need to surrender that wallet to the government. So what you do is that they will transfer all the available cryptocurrency from your wallet to the government wallet, or any other asset that digital asset that has been confirmed to be part and parcel of the crime. Yeah. So, yeah. Any question? Today we had to move a little bit faster because of the certificate ceremony, and yeah. Question? Question, comments? About the training? Yes.
I'm just curious about the availability of technical skills. Since you said it, the experts in this domain are still few. Even the facilities, like in Rwanda, we have only one forensic lab, which belongs to the government. So if the same, let's say like a criminal situation where our forensic, the National Forensic Office is assisting the prosecution, what will be the avenue now for the suspect to find a way to contradict this report that is coming from the only one lab that we have? I don't know the advice or kind of, because this has been like the question my colleague was asking before about the way of contradicting the prosecution while bringing the charges, and how to assist the suspect and contradict the thesis from the government using also technical expertise.
Yesterday, the guy from yeah, I think yesterday you explained to us something like that during lunch time. I think, can you maybe?
Thank you. So what I can say, the point number one said that Rwanda Forensic Institute belongs to the government. Actually, in the sense, it's not like that one. It's true because it was no need to take the digital forensic from the RIB or from the police. So the policy is say, I can even give. It's not a security. We do have I did myself 2 cases to contradict what they did from the police under RIBs. Means even Mwalimu have said, expert witness is an independent. So what I do is not for against any part, is to present a scientific evidence. So means we receive the case. But when it comes to you to have maybe my report and then you need to reverse, or you need to know it as a lawyer, it's so difficult. It's difficult. So my solution is this one. From this training, even other trainings will be coming. So we need to have this defender who are trained, at least could understand and interpret the report. This is the solutions that a defender used to be even involved, all these experts. Number 2 or number 3, guys, you have to trust me. I'm just the work. I used to be, let me tell you, I used to be on the side before I worked to the CID. And later, we shift the CID to be an independent forensic laboratory to deliver these scientific evidences. So you have to trust these people, okay? And then nothing. We need people from defense who have been trained. You can go in somewhere and then be trained. and you'll be able, even Mwalimu is an expert witness. Do you think that he used to be a police? No, just be trained, have the mandate, maybe different from Rwanda to the Kenya, but things easy.
Excuse me. The point is on the availability of tools. Let's say we have in Rwanda only one lab that can test the DNA. Let's say I take DNA as we have only one lab, and if the government is using this lab, and I have to defend myself against that, I don't have any other way to do that. So I was like to get some advice, and
I can share the experience. It is costly, but you have the way you can even do that. It is costly. I can give the example for DNA. We do have said, if you contradict by saying the result from the lab is not clear, you can even approach. But the things, maybe soon we shall have the evidence law. It's not you who decide that I have to go and do contra expertise to another one. You have to have the authority. You have to have the recommendation from the judge, okay? And then say I have to go to the Netherlands. Even in Kenya, they do have this kind of these facilities and whatever. Maybe people have to be discussing. Don't say that in Rwanda, of course, we do have these facilities. It's very costly, very expensive, even much expensive. So now, simple, if you had this case, for you to say, I do not accept this one, who you are first of all. So what you do, you have to, we are now in East African community. In East African, we do have Uganda, Kenya. You have this kind of maybe laboratory. You have to ask, and then judges, maybe, I don't know the procedure exactly, but the facilities are there. Maybe in Rwanda, we still have the issue because these are very expensive tools, even very expensive trainings from that one. So the solution by now, we need to trust the forensic laboratory as independent. I give an example. We do cases not only to the law enforcement, even to the private. Even we work closely. Many cases I do receive is from the defendants. Yeah. Maybe we should have even maybe one time come and visit. We should even give you the details about what we do there.
I think what I can gather there is you use mixed laws, the civil and common law, and Dubet standard. The judge is the gatekeeper. So the judge will determine whether you get an expert from somewhere else to rebut this expert. So I think it is the judge to decide about that, and which there's a leeway. Yeah. Yeah. Yeah.
Thank you for your presentation. I have a question on the reporting as far as the forensics are concerned, because as we know, reporting is about giving an opinion. An opinion is generally based on facts, but the one who gives an opinion may be subject to errors which are not material. There can be some errors which are not very, very material, but the opinion is there. Is in forensics a leeway for an opinion which maybe can be taken as which would, for example, can take an example of an opinion in financial statements. whereby an accountant may give an opinion that he recognizes that there may be some errors which might be due to fraud, for example. But what he certifies is, my opinion is based on material things. And my question is it the same in the forensics as reporting is concerned, or the opinion is concerned?
Yeah.
If my question is clear or not.
Yeah, I get you. Your report should reflect your opinion. Yeah. And your report should be based on facts and facts alone, and should be methodical and systematic for it to be admissible in the court of law. And that is why when you talk about material and non-material, there are certain things that you can be doing during the course of, in the course of your investigation. Remember what we talked about in the ACPO principles, that if you have to access the original data, then that person must be trained to do that, and he should be able to explain the consequences of his action. Okay, so that can be material or not material. But the provided that your report says that, yes, I had to access the original data because of 1, 2, 3. Okay, and for accessing the original data, this is what I did. And these are the slight consequences of this action. Or these are heavy consequences that may make this data, this evidence not reliable. But what I did has got very little consequences on the results of the results of this investigation. So those you can make those assumptions in your report. So it is also possible with the forensic in digital forensics. Okay, satisfied?
Yes, yes, I'm satisfied. As far as materiality is also concerned, considered in the reporting in audit.
Okay. All right.
Yes, thank you very much. There is one important factor that you mentioned where you talked about the procedure you have in Kenya in terms of how the expert witness testifies in court. Unfortunately, here we have a different scenario, which I believe sometimes we have mistrials for reasons that can be avoidable. When you see a prosecutor, let's say in criminal cases, a prosecutor comes and then testifies. When a prosecutor is reading this report, he's testifying. We can assume that is direct testifying. And in law, we call it hearsay. By principle, hearsay is not acceptable. And when the prosecutor is testifying, the law also gives the other party the option or the right to cross-examine. Because after the submission of your witness testimony, as an expert, you can be cross-examined by the other party. We don't have that one here. It has to be a request now to also have a postponement, request the other party to come. So you can see, even sometimes people don't give the value to expert witness and the cross-examination. People don't take time in analyzing these files because there are cases we meet and then you ask questions, exact questions from the reports. You ask about the report, information from the report to the prosecutor, he cannot explain anything. So these are the things I think, I understand we are using a hybrid system, but we also have to understand the processes we are trying to use. If we are using a witness, if we are using an expert as a witness, can we at least have that expert come and explain to the court? And even a court who can raise questions to understand deeply about the matter. And the problem I saw is that the report is not read in detail. They only look at the opinion. But the opinion is an understanding, and as you said, is an understanding of the
this one, but there is a process. You talked about the chain of custody. You talk about the evidence correction, all that procedure. That is not looked at here. If they only go for the last part and the conclusion or recommendation of the expert. So I believe from what we have discussed here, we need to see how in the criminal justice system we have to change this process, especially when it involves experts. And also there is where the colleague here mentioned about counter expert testimonies. I don't know, maybe we're going to find, but when you look at even the evidence law we have here, it talks about that any witness, be it any witness of any nature, an expert or any random witness, their testimony is valuable only if it is submitted in court by themselves. But in practice, we are doing differently. That is a big problem. Then let's say when someone gives, like an expert, you give a report. If I want to challenge your report, I don't challenge it as a layman. I can challenge in details when maybe in law, the procedure of chain of evidence custody and the chain of custody. But I can challenge in details or elements of a forensic expert if I don't have a counter myself, because I can as well have an independent expert who can do a counter expert report. Then when there is a contradiction between two experts, then the court can decide either get an independent appointed to give their, he can either corroborate with the two experts or issue an independent report that can be based on by court. So I think there are some things that we do ignore, but which are very important. We cannot wait for court to order just depending on that we are contesting this witness, the expert witness or what. It's not about credibility. It's not about anything. We're just contesting. Let's say DNA, I'm saying, I don't accept this child is mine. This is wrong. No, you have to provide a different report. And then when they are contradictory, the judge can choose an independent one. I believe it's understandable in that manner. Thank you.
Yeah, I think it's a matter of the rules of evidence. It seems like in Rwanda, the rules of evidence is neglecting, I don't know, or what to use, the scientific procedures. Yeah, so I think that should be addressed in the new Evidence Act that is coming. Maybe you can tell us about the new Evidence Act. Mm-hmm.
Thank you. Let me start to the comment, to the question from the opinion and the conclusion asked by my friend. In practically, we have two things. For us, we have to use to distinguish within. There is a conclusion. When you say conclusion, the mandate or the mission says, expert, tell us, have you found this kind of historical emails, message, and so from this mail? I say, yes, I found this and this. This is my conclusions. And then the next question is asking, what is the intent? When it comes to the intent, me as expert, I have to justify as the opinion by saying my experience according to this and this, the intent behind of these things, my opinion as expert. But I conclude that this exactly the information and the data, now call it as evidence, has been found from this particular, these are the conclusions. Actually, mostly they need to conclude, confirm these things. Now, when it comes to help the judge from the opinion, I give the opinion as my experience, number one. Number two, when you say it is not allowed to have the expert witness in the court, my side, I say it's not true. Maybe your experience, these are the new. We have to agree, guys, all of us here, we have to agree, these are the new. We are lucky enough for forensic. We do have these equipments and the trainings. We do have many cases where I go, I do the report, and then, so what I have seen, the judge asks, once they read the report, say there is no need to call the expert witness. Do you agree within this report, both sides? He say yes. Now let me use the report. Or sometimes he need more details about the report. He used to call us and then explain what about this one. Now about the details, mostly we do have the RIGO report, but we also add attachment for each and every step we use to handle, to acquire, to analyze, and the findings from the actually we do have some report from the tools. We do make attachment. So from the court, I used to see only the report, but if you need to know exactly what the chain costed has been done from the details, also we do have send the attachment on that one. So this is my opinion. And then from the law, my friend, soon we'll be having the new one. At least it has been defined. It has been even removed all this ambiguity by saying, once, for example, you need to contradict this report. What do you do? By now, they said the judge has to delegate the 2 or 3 experts, and then later used to be receive the report from the expert. So this is the evidence law, the new evidence law soon be published. Maybe I don't know exactly, but has been done from the parliament. So we need to have to see, and also it has been including all this about scientific evidence, which is not available even for before.
Thank you, Mr. Presenter. I'm Nicholas. I just have a few questions to ask. I'm a bit handicapped that I may be limited to ask because I was unfortunate that I didn't attend yesterday's session. Even today, I just happened to come late, but it seems to be an interesting session and interesting field. In fact, although the time used to train us has been just so short and we've not had enough to learn from the course as well. Well, I just want to ask maybe as a private lawyer or any private person would require maybe to have this this course. Is it available in Kenya or anywhere around? I mean, how much would it cost? How long would it take? At least for somebody to get the principles and the basics of the knowledge about the course here. I mean, that's my question. Thank you.
Yeah, this course is organized by East African Law Society. I'm just a facilitator. So if there are such courses to be done, I think Gabriel is here. For more courses.
Well, I didn't anticipate I would be answering questions, but nonetheless, it's my honor too. So you're welcome, for starters. It's regrettable we didn't have you yesterday, but at the East Africa Law Society and under the East Africa Law Society Institute, we offer an array of courses, not only on digital forensics, but we have several on arbitration, mediation, we have FIDIC contracts, we have the in-house counsel convention coming up in July in Mombasa, and we do offer on a weekly basis, we do offer 2 online courses every week rather. So that's on Tuesday and Thursday. So we are constantly doing capacity building for members. And if you want to know more about these initiatives, you can visit our website. We are here to add you to our mailing list if you do not receive our emails. And yeah, if you have any further inquiries, we're happy to provide you with the information.
Yeah, thanks. I was just asking about specific about this course. I mean,
yes,
this knowledge, because
yeah,
it's a field that seems to be lacking. We're lacking here. It's,
yeah,
evidence required, and it's a really good field that we have to specialize in, like as lawyers, as investigators. Because, but I've seen there's a few maybe it would be of more beneficial to maybe staff from the Rwanda Investigation Bureau, the prosecution and such. I wonder how you made your choice for the attendance here. But I think it would be really better for the Rural Investigation Bureau officers and prosecution department. So I was just asking, at least for an individual, if one wanted to specialize in this, what would of what? How can one attain it? Can one go to Kenya or to any other place around to have
Yes,
special?
now I understand what you're saying.
Yeah.
So what we've had, this course has been undertaken in so far 3 partner states, that is Kenya, Uganda, and Rwanda. It's moving to Tanzania, South Sudan, and probably Burundi. So what we're doing, we are trying to build a cohort of lawyers whom we intend to pick interest in this emerging area of law. And then, of course, definitely, it's like you're preempting what we want to do next, which is to have an intensive, in-depth training on this particular subject. So this is more like the first phase of it, the pilot phase of it, and we'll be able to roll it out intensively with certification. Because I know you're asking about the certification bit of it. So we are working on that at the Institute with our panel of trainers and experts to see how we can grow this training.
Yeah, this seems to be an mind opener, maybe, to know that it's available, it's around, we can find it, we can look for it.
Yeah.
But really, it's not enough at all. It isn't enough at all.
Yeah.
We need more about it. Huh?
Yeah.
I think you agree with me.
Yeah, that's
thank you.
That's a good observation.
Any question, any comments?
Thank you, Mr. Trainer. Thank you for the training. It was very interesting, and we have, I think, gained too much. According to the point on which the expert was talking about, our colleague from the Institute, the Technical Institute related to forensics, he was talking about the attachment of the expertise he made. These attachments were put where, since the ICMS, the system on which we plead in, is not accepting the videos and even audios. Now, I would like to get the precision from him, since the ICMS is not accepting the.
Thank you.
Before responding to the point, I would like also to mention or to highlight a point which is very interesting, in the sense that since our judges are not informed of these digital forensics, it will be very difficult to achieve really if I can say, the justice related to digital forensics. Because even the natural evidences, they can sometimes not take it into account, because there are things that they cannot understand. Are you planning to take them in training also, or if not, it will be very, very, very difficult for us, because we will just be informed on our side, but on the other side, it will be in the darkness. Thank you.
Gabriel, before you answer, can you, yes, asking about they are trained, and the judges might not have this knowledge. What is your take? Are you planning to train the judges?
Mwalimu, thank you for strategically sending those answers to me. Yeah, but that's a going concern. Why? Because in the field of access to justice, you'll notice that all players play a very pivotal role in ensuring that justice is dispensed at the end of the day. And sometimes skilling legal practitioners in such an emerging area and not skilling judicial officers could sometimes be foolhardy. And the beauty of this is as ELS, we do organize bar bench forums, regional. So in these regional bar bench forums, not only do we discuss matters and issues that affect the bar, but also we look at some of the emerging areas that, that the judges could probably take cognizance of. And that said, we will have a bar bench forum ostensibly in July, late July or early August. And at that avenue, perhaps we'll propose this particular training for the judges. And once we get the blessing of maybe the PJs or the chief justices who will attend that forum, then we'll begin rolling it out. But most importantly is to arm our foot soldiers, because you guys play a very important role when it comes to investigations and hearings in court. So if we are not skilled at the earliest point, then it's a disaster. In my practice as an advocate in Uganda, I found myself sometimes, of course, judges are often seen as custodians of the law. But as a legal practitioner, you are an officer of court, and sometimes you find yourself educating these judges in your submissions, although some of them don't take it nicely. But sometimes if you have, new precedent or some new knowledge from somewhere, it's good to apply it in your pleadings, apply it in your submissions. You test and see, of course, in line to what the civil procedure rules of your jurisdiction says. Yeah, so I think with this knowledge that Mwalimu has given us, we should use it. I have 2 success stories, one from Uganda, one from Kenya. There are 2 lawyers who have successfully used this knowledge in prosecuting cases. And yeah, so far it's working for them. And I hope it does work for us all here today. And like I've said, we've taken note of this. When we have the bar bench forum, we'll be able to discuss it further with the judicial officers. Thank you.
Thank you. Thank you again. Let me just even have just a second talk about the judge training. Have you seen that from this kind, we talk about 2 things. Talk about scientific and a specialized area of fields. So judge, I don't know, have the information about that one. But really, that's why we need this specialized guys and the scientific one. But the really good news for you, if you had the president of RBA said, we do have the MOU between Rwanda Forensic Institute. So before we work as a laboratory, when you say institute, very soon we'll be having an independent department, rather even a college for training, even certify. If you're interested from that area, from maybe college, maybe talk about digital forensic, we already even prepare, we have been even prepared the curriculum and whatever. Soon we'll be have training today, each and everyone. Don't think like this is a government. It is an independent, as I repeat again, and then we'll be having all these departments for training. So very soon we should have all this one. And then we do have MOU for training. So it is under the process. So let me back to the question for attachment. So by now, we are not yet have the account to the ICMS by now. So what we do, once we finish the report, then we collect all these attachment. Attachment I mean here is all these procedures, movement, the whole entire chain of postage we use, and then we put it into the storages. We have the storages, the CDs, and so on. These are the attachment. Now we give back to the requester plus the report and the attachment. And then once it goes to the court, what I have experienced, the judges used to read the summary report. These are the summary report, and then straightforward go to the conclusions. And then I want to say the report is clear. For example, if the request was saying, could you analyze and assess this video to give us the authenticity within this one, and then whatever. We give the whole summary, and to the back we attach the tools, a report, and then what they do, he use only to do the summary and then go to the conclusions. Now, for us, there is no way to attach. What we do, we only send the report to the defender. I told you that we do have even the case from the defender. So the defender, he used to put the report to the ICMS and have also this attachment. I don't know what happens if it will be also adding, but mostly you and the judges used only to have the summary report, executive report. So maybe we should discuss about, discuss with the ministry the way you can have the account. Once I finish, I could even upload all these things, but it is under process. I do have even those queries. But today, it's only put all these attachments, including the report to the CDs or to the storage has been confirmed and then sent to the judges. So no way to add all this attachment to the ICMS.
Satisfied? Any other question?
I have a suggestion. Is it possible to organize another training on non-digital forensic evidence? Digital, but on non-digital forensic, like on the body, physical, DNA test, and so on. It is very interesting for us.
Gabriel is, I think Gabriel steps out. Is the right person to answer that? Yeah. Any other? Concern? Question? Ladies are not asking questions.
Thank you. My concern is about with the defense lawyers. With the defense lawyers on our side as lawyers, the practitioners. So I've been curious to know how could we benefit from here since we have seen yesterday that the forensic evidences are authorized by the government, the judges. But for us, as the trained lawyers, how will we have that access to work with the authority, so that it will be easy to convince and how to access on the data that are from the authority?
Actually, the question was the same. the accessibility of this kind of, let me take the terms scientific evidence, not digital forensic. All of these kind of DNA, toxicology, whatever, the issue by now as scientific evidence are new. So the way, number one, we need defender who are trained. That's why I like this training has been organized by ESC. At least you have to be aware. You have to be aware that DELA is a scientific evidence in your journey. So I don't know if I can encourage you to even join different trainings to understand, not only understanding about the practices, but the principles, the logic, the procedures, the way to accept all these things. It could be a recommendation for you to join, because this is your defender. You are subjected also to know way to escape, because you have sometimes got these cases within direct electronic evidences. The number one recommendation is to understand. So the next, after having the TP training, you'll be able to know exactly how can I approach this kind of law enforcement agents like Rwanda Forensic Institute. I told you, I can even confirm, this is not a unit from the NPPA. It's just for standing to the scientific evidences. So we provide the scientific evidence. We help the prosecutors to interpret, to know exactly what have to be sent to the judges. So these are the recommendations. So we encourage even younger defenders here to be not sweeping, just study. Even so, they do ask which kind of course do we even join? There are so many courses. Guys, I do welcome you to the Rwanda Forensic Institute. If you need to know which even the career path you can even do, we have MOU, you guys, from you. Maybe it is under process. We be help you guys to know how could you be prepared ahead for these cases. This is what I can say. Maybe others.
Thank you. I think previously we had a training conducted by Rwanda Forensic Institute, training lawyers on this use of the forensic evidence. And in that training, I think, if I remember very well, it was around March in a convention. So in that training, there were two things maybe on the center, on the focus. How forensic evidences are obtained, conducted. That chain of custody we've been told or been trained on since yesterday. How is it? How are they? These evidences obtained, preserved, conducted, reported, and taken back to the people. And then the second focus was who are the people maybe can access those evidences, but the responsible people, who it's made for who. And I think that's why the idea of the Rwanda Bar Association came to intervene, just has become the partners with the Rwanda Forensic Institute, that even lawyers are entitled to request for a forensic report, forensic examination, forensic evidence. As long as you feel that it would help you to defend your client, you have that mandate to request for the forensic report or forensic evidence. So I think if some of us would have attended that training, we would have got much better. And we are told from that training that we also, the Rwanda Bar Association is organizing a visit to go there and see how these different departments are working, are operating. What are they using? What are they telling us? Is it exactly what they are doing there? Do they have those or materials they are saying? Do they operate in the way they are telling us? Because we had different trainers who came from different departments from Rwanda Forensic Institute telling us what they are doing. How do they do it? The procedures, the techniques. I think maybe if Rwanda Bar Association organize it properly, we shall be having some lawyers going there to visit and see how it is operating and who are mandated to have that report, who are responsible people to request for that report or that evidence.
Okay, thank you. Maybe just to answer that question is, I think you are speaking prophetically when you say RBA was organizing a trip down to the forensics office. It's on that point that I would like to inform members this afternoon at after lunch at 2, we'll be going down to the forensics office, and they've graciously offered to host us this afternoon. So after lunch, we'll take a trip down there. I think they deserve a round of applause, really. Yeah. So to see, like you've said, put into practice what we've been discussing here for these 2 days and the knowledge that you could have gathered from previous trainings, we'll be going down there just to see how the different departments work and also getting to know their perspective. Yeah, so from 2 to about 3, we'll be heading there, and then we'll be back at 3 for the awarding ceremony. Yeah, so we're still taking more questions if there are any other. Mwalimu, sorry, I had to interject. Yeah, because question? Yes, yeah, yes.
On what you have just informed us, I'm wondering, instead of going to LIFI and come back here, why not the award ceremony and then we go once and for all? If you could look into that, thank you.
That's an interesting suggestion. I don't know what members think, but we had organized it as so because the award ceremony will involve some very high level people whom we had asked to come here at that time. Yeah, so we thought we would finish our phase of learning, both theoretically and practically, then conclude the training session. So the visit is like the last session of the training. So the training is still ongoing. We've not yet, yeah, thank you. Yes. Any questions from Mwalimu here before we break off for lunch? Brenna?
No.
I hope our lunch is ready. Thank you.
Yeah, I think that brings us to the end of this training session. And I hope that the content that you received is going to help you on your day-to-day work. If there is any comment, anything that you want us to add in the future, you can also let us know. Any improvements? Okay. So is over to you. Oh.
Sorry, it's not a comment on improvement per se. It's just a request. I don't know if maybe you mentioned this and I didn't get it, but is there any way that we could get the slides, the presentation for future reference, and maybe your contacts just in case? I mean, this was like an introduction for some of us, and maybe I will go and dive deeper and get interested, and maybe we'll have cases that we could potentially discuss in future. So
yeah, I think the slides you'll get.
Yes, so the slides will be shared. Like I did mention early in the morning, we will create a WhatsApp platform where we'll share all the slides. So Brenna will be sharing you that link to join the group on your emails. So when you get it, you just click and automatically join that group and we'll share everything. But also you'll get the slides on your emails. Same applies to our online audience. Please do drop your email addresses or WhatsApp numbers on the chat section and we'll be able to pick them up. Thank you.
minus any comment, any question, I think I'll hand it over to Gabriel.
All right. Thank you, members. You've been an amazing group. The training continues. We'll be heading to the forensics office for a practical a bit of this training session. For our online audience, you've been a great audience. We'll try to connect you to the visit. We're still trying to work out with our technical team to see whether we can have that live streamed while we move to the site so that you also benefit and get some best practices. I know you're from different countries, so you could learn some of the best practices that are happening right here in Rwanda. So we're breaking off for lunch. We'll have our lunch break for 1 hour and 15 minutes. So we'll converge again at 2 p.m. So we're adjourning till 2 p.m. We'll converge here and then start our journey to the forensics office after lunch. Thank you. And lunch is served at the same venue where we had it yesterday. Bon appetit.